Hi, everybody. Thank you so much for joining us today. I am Michelle Morris from Consolidated Planning Group, and today we have Randy Narkir with us. He is in Florida and he's from Legacy Solutions. Is that right? Legacy
Yeah,
Solutions
that's
Law
right.
Firm. Perfect, perfect. And he is in Hollywood, Florida. Now, the thing is that, a lot of the stuff that we're going to be talking today about, with Randy being the attorney and he's in Florida, is going to be Florida related. Uh, Consolidated Planning Group is in Houston. So, why are we working together on this? It's because Consolidated Planning Group works all across the country. We can work with families who are in Florida, Hollywood, Florida, or Hollywood, California. Or if there's a Hollywood, New York, or Illinois, or whatever, we can work with you, even though we are located in Houston, Texas. I almost said in Indiana because that's where I grew up, but we are in Houston. So thankfully, the internet and all of this great Zoom stuff has given us the ability to truly work nationwide. Um, we are, first and foremost, Consolidated Planning Group. We are financial advisors, but we are one of the very few financial advising firms across the United States that focuses on serving families who have an individual in their life with any kind of intellectual or developmental disability. We've been in business for over 30 years. We have been doing, life insurance and financial services. We've won awards on those areas, but we're also members of the Special Needs Planning Academy. We are National Certified Social Security Advisors, and I am a chartered special needs consultant through the American College of Financial Services. Almost every single client that we have has an individual in their life with different needs. So we take this very, very seriously. And families come to us when they're thinking of, protection plans for their family. We do life insurance evaluations and we do sell life insurance, as well as disability income protection and things like that, long-term care. We help plan for the lifetime care of your family. Most financial advisors plan to the end of their client's life when they go through their careers, they go through retirement, and then they pass away, and that financial plan ends and that planning ends. With us, we plan for the end of not just your life, but all the way through your child's life as well. And that makes us very different. We can help with all areas of special needs care planning, from able accounts to special needs trusts and transition planning. What happens after high school? What happens later in life when they need residential care? And how you can use different vehicles like the able account or different buckets of money to make sure your loved one will be taken care of. We are here to advocate for you and to educate you. And we come from being parents of children with disabilities. The owners of the company have four children altogether, and three of those four have disabilities. My husband and I are the other two financial advisors on the firm, and we have two children, and one of them has needs. So we are parents. We have been through it. We know your life and what you're going through. And, when you think about all of the financial advisors in the United States, you might find it kind of hard to find advisors who get this stuff. That's because out of 263,000-ish financial advisors in the United States, fewer than 200 focus on special needs planning the way that we do. That's less than a tenth of a percent. So you are truly in the right place when you are with Consolidated Planning Group. Now, we know it keeps you up worrying and thinking about how your child will be taken care of after you're gone. That's why today's webinar is so important, because Randy is going to help you understand the legal perspective of what you need to do, and Consolidated Planning Group can help you figure out the financial perspective. So, starting the planning as early as possible is going to give you a longer runway to be able to make small incremental changes that are going to feel a lot easier than if you wait until later in the game. Wouldn't you say so, Randy?
Yeah, that definitely makes sense. There's nothing
Yeah,
more
yes.
stressful than trying to plan when you're in a situation where somebody's not feeling well or there's a crisis situation.
Exactly. Crisis planning is no fun. I mean, none of this planning is fun. Nobody wants a financial plan in their Christmas stocking, but it's important and it's better to get it done. And hiding your head in the sand is not going to help matters. So start thinking about, what's going to happen after high school? What's going to happen in terms of educational programs or vocational programs? If those aren't right for your family, maybe a residential program. Or day programs might be better for you. What about what's going to happen after you pass away? Think about those things and think about what you want your family's future to look like. You also want to make very careful, detailed communications with your loved ones. These might be some hard conversations, but they have to be had. You want to think about, maybe right now the sibling is saying, "Oh, I'll take care of little Jacob when you pass away, Mom. Don't worry about it." But once the time finally comes, it might feel more like an obligation, and that sibling might learn that they've bitten off a little more than they thought. So that the feelings of resentment can grow there. So just be careful. The feelings of resentment can also grow on little Jacob's side because here's big sister. She's been his best friend and his partner in crime for so many years. And now she's stepping into the role of caregiver, which might feel like a little bit more of a parental role. And, maybe little Jacob said, "Hey, you're not my mom. You're my sister. You're my friend. I'm not going to listen to you." And that can also create some tension. So just think long and hard about having a sibling automatically step in as caregiver. Okay. There are other pitfalls there. I won't get into all of that. Um, I don't want to take any more time from Randy Narkir. He, like I said, Legacy Solutions Law Firm. We're going to have his contact information in these slides, of course, for you. A couple things I want to let you know before I turn everything over to Randy is that we always record our webinars and we put them on our YouTube channel after the webinar is finished. So you will receive an email later on today with a link to the recording on our YouTube channel. And we also will send you the slides as an attachment to that email. So you will get all of that information. And the other thing I want to remind you is that we can't see you or hear you. The best thing for you to do to ask questions, and we love questions and comments, is to put it in the chat box. And that way I can monitor the questions and comments while Randy is presenting and make sure you get as many questions answered as possible. So, Randy, without any more further blabbing from me, I would love to turn this over to you and hear from you about future proofing the journey.
Thanks, Michelle. First, I'll just say Consolidated Planning Group is phenomenal. So if you have any
Oh, thank you.
questions about your finances and how that's going to work in the future, you should definitely reach out to them. And at worst, you'll get some good information. And at best, you'll put a plan into place that protects you and your family. The purpose of this presentation today is really to just give you practical, on the ground advice about what our families face on a day-to-day basis that we help with in the realm of guardianship. And you can go to the next slide, Michelle.
Sure.
Um, so I'm going to stick on this slide for a little bit, and I'm going to talk about what people have told me in terms of guardianship and guardianship alternatives. So let's start with, first of all, if you have questions throughout the presentation, please put them in the chat. I know Michelle already said this, but we're going to cover a few different topics here, and sometimes you'll ask a question to kind of forget the context later on, so it's good to interrupt me as I'm going through it. So why guardianship and guardianship alternatives? Why, if you have a child or somebody else in your life who has developmental intellectual disabilities, are we talking about guardianship? Um, the reality is that when a child in the state of Florida turns 18, no matter how they can participate in life, whether they can go to school, trade school, get a job, from fully and participating in life that we would say, people do on a day-to-day basis, from being bedbound, or wheelchair bound, or being completely nonverbal, or not being able to participate in life so easily, no matter the case of what your child, and I say your child because it's just what naturally always slips out of my mouth, is facing or dealing with on a day-to-day basis. Once they turn 18, the law draws a hard line. And the law says that your child is now an adult and that your child can make decisions on their own. And in fact, nobody else is legally allowed to make decisions for them anymore. Um, Practically, this makes no sense. Practically, we know that most 18-year-olds can't manage their own life. I don't care if they have any special needs or not. And in terms of doctors and medical care, um, HIPAA starts uh, coming into play where doctors don't have to speak to you anymore, in terms of any third party out in the world. And this is actually what I call the gatekeeper problem. And that's what guardianship is actually the solution for. You want to help protect your child. You want to help let them participate as maximally as they possibly can in the community. You want to help them thrive. You want to protect them in every way you can. And the law has a lot of roadblocks that let that happen. And do you need guardianship or guardian advocacy? No, unless somebody tells you that you do. And the families we help either deal with that right away because they have a 17-year-old who is now turning 18 who has significant health issues, and there needs to be a continuity plan in place. Or there's, higher functioning individuals who have no health issues, and there's really nobody that they need to make decisions for. The child lives at home. No third party is asking for any authorization, but those families want something in place to make sure that they can come in and protect their child if one of these third party gatekeepers out in the world says, hey, mom and dad, or aunt or uncle, or sister and brother, um, who are you again? No, no, you can't sign this piece of paper. No, no, this doctor can't talk to you. No, you can't request medical records from one doctor to send to the other doctor. And the gatekeeper stops you. Guardianship and the alternatives to guardianship are the solution to you doing what you naturally want to do and setting up a plan that if you're not here anymore, that another party could do that for them. The solutions I'm going to talk about are guardianship, guardian advocacy, power of attorney documents, and supported decision making. None of these solutions are ideal in every situation. And I'm going to talk a lot about the challenges around the solutions and how you can think through what makes sense for your family. I'm not a big fan of saying, hey, you need this. I'm a big fan of giving you information. And as smart individuals who know your family better than I ever could, make that decision on your own. So that's really what I'm going to try to do in the rest of this presentation. So let's talk about what these tools are. And then following this, I'm going to compare them with each other. Guardianship is really a two-step process, at least in the state of Florida. If you want to pursue guardianship for somebody, and that means that you are requesting the court sign an order that you can now make decisions in important areas of your child's life. For example, medical decisions, financial decisions, contracting, hiring attorneys, choosing their social arrangements, choosing where your child lives, things that you need on a day-to-day basis. Guardianship, the goal of this process is for the court to say, let's say your child is Jonathan and that you can now make those decisions for Jonathan the same way you could make those decisions for Jonathan before Jonathan turned 18. And this is a two-step process. Step one is you have to ask the court to make a determination that Jonathan can't make those decisions for himself anymore. So practically speaking, what happens is three physicians or mental health professionals are assigned to evaluate Jonathan. And this is a little bit of my cynicism. In a completely insufficient way, they will evaluate Jonathan's ability to make those decisions for himself in a very quick amount of time. And they will file a report with the court that says that Jonathan can't make these important decisions for himself. You can ask the court to let you remove all of Jonathan's rights that can be removed under the law, or you can pick and choose certain ones depending on your child's circumstances. The court will also appoint an attorney to represent Jonathan, and that attorney's job is to make sure Jonathan is protected in the system. Why does Jonathan need protection from his parents? I don't know, but the court says they do. The reality is that you are trying to take away somebody's rights, so they should have some protection. And guardianship law was not made for individuals with developmental or intellectual disabilities. Frankly, it was made for people who are in catastrophic incidents or people who become elderly and lose their capacity to manage life anymore themselves. So we're trying to shove this solution into the hole to solve the problem that you need to deal with these gatekeepers out in the world. So that's part one. If the doctors agree that your child cannot make these important decisions, then part two is you ask that you be appointed as guardian of your children. There's other alternatives to asking that you be appointed. You could ask that other family members be appointed if you're much older and don't have that ability anymore, or you can even ask that a professional be appointed. And that's the guardianship process. Guardian advocacy is, I don't know if it's exclusive to Florida, but it's unique to Florida. And it is a guardianship program for individuals who have intellectual or developmental disabilities. Nobody else can file under the guardian advocacy statute. And it's just like guardianship, except it's a one-part process. The court does not need to find through a separate case that your child is incapacitated. They just need to find that they have an intellectual or developmental disability and that they need somebody to help make decisions for them in life. And it's a very similar process, but there's no doctors appointed, but an attorney is appointed to represent them. It is like guardianship. It's like a guardianship light. Those two are very similar, and there are some slight differences that if you guys have questions, I'm happy to answer. I can answer specific for you anonymously to see if you want me to help you think that through. But the next option is very different than both of those. It's power of attorney documents. I don't know if anybody here has done their estate planning before, but if they have, adults in this country typically at some point will sign a will, and along with that, they'll sign some other documents that say, hey, if I can't make decisions for myself, I name my spouse or my child to make those decisions for me. And you can have your child, if they can understand what the documents say, sign these documents allowing you to make the decisions instead of going to the court to be appointed that way. I'm going to talk about the pros and cons of all of these solutions soon, but it is a way for you to be appointed to deal with the gatekeepers out in the world. The last option is supportive decision making, which interestingly has been in law in Florida for about a year now. And around the country, it's been in place a little bit longer. Happens to be I was involved with the organization that was advocating for it here, and I'm glad it's in place. But it is not a substitute for any of the other three options, in the sense that in supported decision making in Florida, somebody can be appointed to get information and help support that individual as they live their own independent life. but there are no provisions in the law for supported decision making to substitute you or to allow you to make legal decisions for your child. However, the main benefit in my mind, and I was advocating for supported decision making before it was legal under the law, in a contractual arrangement between, let's say, parent and child. And I was doing it on a very granular basis. And let me explain what I was doing and why this is good for some families. Um, Getting a little bit ahead of myself, I'm a huge proponent of autonomy of people. And I think people who can integrate as much as possible into the world and reach their potential as much as possible are typically happier people. And I would and do use supported decision making to help mediate between parent and child, to delegate tasks between them, and try to help maintain autonomy as much as possible for somebody who has special needs. What does that mean? That means we chunk things up much smaller than saying medical decisions or personal decisions or financial decisions. I would break things up as, can John get dressed by himself? Can John put on his socks? Can John shower by himself? Can John brush his teeth by himself? And we would go through all of these different line items, like a very long questionnaire, and celebrate when John could do certain things, and then set goals of new things that John could do. And this was a way of creating autonomy and also helping John understand when John needed help. Now, obviously, this is not for everybody. If you're, lower functioning on the autism spectrum, for example, this is not going to be a solution. But it is a way for individuals who are higher functioning to be able to thrive without having their rights taken away. We can go to the next slide, Michelle. I got a little bit ahead of myself. The power of attorney documents are broken up into three categories: medical, financial, and school and program. This is not standard. This is something that I've done in my practice. And actually, my mentor taught me to do this. And the state, the nonprofit that helps terminate guardianships for people with special needs that don't really need them, use our documents that we created. And they're very simplified forms that are practical for individuals with developmental or intellectual disabilities. They're not overwhelming, and they allow a parent to make decisions. Again, I keep saying parent. A parent to make decisions for their child in a way that makes sense and is as simple as possible, and that will satisfy the gatekeepers out in the world. And we can go to the next slide. So supported decision making, I do want to talk about it a little bit more. It is part of a system that I like to put in place for individuals who are higher functioning, and is not just about legal documents, but it's about planning for life and planning how things are going to move forward and clarifying who plays what role, who agrees to what responsibilities, and who to go to for help for different situations, and who's going to be there when those key people are not there anymore. This is what people come into my office and start crying about. What happens when I'm not here anymore? Like it's like clockwork. I can, and it's not but it's so predictable. As soon as we start getting to a discussion about, hey, what happens when I'm not here? Our parents start crying because they invest everything into their child, and nobody can replace their child. And they can't imagine a world where that doesn't exist anymore. And what I tell people is usually, almost always, when we have a good plan in place, it will not replace them, but it will help make sure that their child can continue living in a life with dignity and support. And I'm a huge fan of self-determination, and there's lots and lots of studies that when you take somebody's rights away or powers, to act out in the world, it causes depression, it causes anxiety, and it decreases quality and satisfaction of life. So the supported decision making allows individuals to have a say in how life moves forward, the same way anybody would want to. And unfortunately, I don't want to cast judgment on anybody, but there's some parents that just want to protect their child, no matter what the cost, and I understand it. But when you can protect them without reducing their self-determination, that's ideal. A circle of support is exactly what it is. It's the village, to raise a child situation. Having everybody on board and updating those types of plans as necessary. And usually with supported decision making, we supplement it with powers of attorney and advance directives so that the parents can actually step in and make decisions. And if appropriate, if somebody is high functioning and earning money and saving and building retirement accounts, we would recommend an estate plan as well. Or on the other side, if they're getting benefits like SSI or SSDI, we'll work with our families to name a representative payee and or a successor representative payee to help manage that income.
Very good. Yeah, that's so important to have a successor rep payee as well. Um, because, if you are set up as a representative payee, which is great option, and you pass away, your benefits or your child's benefits could be suspended, will be suspended until they figure out who is going to be the next representative payee. So having a successor listed ahead of time is extremely beneficial.
Definitely. All right. I love this slide. It's a little
I
bit
do too. I'm
confusing.
impressed.
Yeah, and I'm terrible at this stuff, but I made this all by myself, so I am proud of myself. Um, but it's a very, very important slide, and I want to compare these to you. This is the most important slide throughout the presentation, because this will help you decide for your family what might be best. And if you have questions, you could reach out to me after. I have some free resources I'm going to also tell you about. All right, here I'm going to go column by column from top to bottom, and we will cover it that way. So let's start with the idea that everyone is different. There's no rights situation. I'm a big fan of telling you what my opinion is, but honestly, I respect everybody else's. And what your priorities are your priorities. So we're going to talk about what is legally binding or not. What can actually move the needle in terms of legal strength? Flexibility. How can things change over time if they need to? Cost for a lot of families, that's really important. Succession plan. Um, which of these tools allows a succession setup? Autonomy. Again, that's a huge priority of mine to create autonomy for an individual. So what's stronger for autonomy? Recognition. That's recognition from gatekeepers, those third parties out in the world. What tool will help satisfy them? And then the last is court involvement. I think these moved off a little bit, but it's okay. Somehow they shifted. It's okay. All right, guardianship. Is it legally binding? Yes, it is the strongest of any of these. When you have a document that says you are in charge, you can make medical decisions, everybody out in the world will respect it. Banks or financial institutions may need to run it by their legal department, but everybody else in the world will say, this document says I can take care of decisions for my child now. And it is fully enforceable. You can use the court to enforce it if you needed to. And it is extremely powerful. Is it flexible? No. There's a strong lack of flexibility with guardianship because I'll skip forward to the last item. There's court involvement. Courts are courts want to protect the public. That is what they're there for. The guardianship process is used to protect children, and especially in Florida, it's one of the fraud capitals of the United States. There are people who take advantage of other people, And this, and even in a just a pragmatic sense, a judge does not want their name to be in the newspaper. So they will require court orders to do a lot of different things. They will want a lot of evidence to be able to use money or take certain actions on behalf of your child. And you need to play within their system. Cost, it's also quite expensive. Um, Out of all of these, it's probably the most expensive, because there's just the most work involved from an attorney's point of view. There's also annual filings if your child has any assets. There's annual accountings you need to do, and the cost can rise pretty quickly. Is there a succession plan? Yes, guardianship has a very strong succession plan because you can just name a guardian. The guardian is replaceable. Anybody could be substituted. I shouldn't say anybody should be substituted, but you can plug a new person into the role of guardian and the case just continues on going on. It just can continue until your child passes away, God forbid, after at least 120 years.
Yeah.
Autonomy, it's the yeah, these got moved around. It's okay. The autonomy is extremely poor because this is literally stripping an individual of their legal rights to make decisions. Not only are you named, just to clarify this, not only are you named to make decisions for your child, they can no longer make those decisions for themselves. So, for example, if your child went to the gym and signed a contract to sign up for a gym membership, that is not enforceable. That could be canceled. They don't have the legal right to enter into a contract anymore. Recognition, yes, everybody recognizes it. And the court involvement is sad face because once you bring the court in your life, they stay in your life. Okay. There's no getting rid of the court. They want reports yearly, they want approval for certain things, and they are there forever. Some people will ask, well, can we get rid of a guardianship? The answer is yes, but it's not so easy, and you would have to have medical evidence to be able to support that, including more doctors to evaluate your child. And it's pretty rare. Usually you'll restore maybe some rights, but not others. Guardian advocacy is very much the same as guardianship. There isn't much different except the cost is a little bit less than guardianship. It's also a little bit more flexible, but not really. And there's a little bit more autonomy when you're comparing guardianship to guardian advocacy because technically you are named as a helper to your child and you can make decisions in collaboration with them. That's the way the law is set up. That's not the way it works though. The way it works is that both pieces of paper, you get a document called letters of guardianship or letters of guardian advocacy. The gatekeeper sees the word guardian, they don't read the rest, they don't care. Okay, so practically, as somebody who's trying to help somebody you love, the world treats those two exactly equally, but it's a little bit easier to set up. Power of attorney documents, very different. They are kind of legally binding, but not really. A third party, this is one of the downsides of the powers of attorney. I'll skip forward. They're a lot less expensive than going through guardianship. It's a one-time cost. But in theory, a third party out in the world could say your child didn't understand what they were signing, and not accept it. And maybe they didn't understand it. Although we're being recorded, I tend to have a somewhat lenient view of what that understanding means, especially if a child has no assets. If a parent is just trying to make decisions about help them with their medical decisions, asking them questions. Do you want mom and dad to talk to your doctor? Do you want them to be able to talk to the people at school? Do you want that, asking questions like that? Um, I help them understand the best I can, and if they can, we'll sign the documents. They're extremely flexible because you could change what they say, and you don't have to get a third party's approval. Is there a succession plan to powers of attorney? In theory, there could be, as long as that's planned ahead of time, naming backup people into those documents if you, for example, could not serve as their agent under a power of attorney anymore. But that person might not be here, and there's no standing entity that somebody can step into. It's kind of like a guardianship is a little bit like a business. The CEO can die and have a new CEO, but the power of attorney is very different. It's just a standalone. There's no entity you could step into. It doesn't exist. It only exists as long as the people named in it to make decisions are there. There's more autonomy. There's significantly more autonomy. There can be a succession plan as long as that's done. Recognition, it should be. I always warn people that there's a risk of a lack of recognition. But it hasn't actually been a problem for the clients I've done it for to date. But it definitely is a potential problem. All right, supported decision making. Is it legally binding? Yes, but again, it's not giving you the flexibility. It doesn't give you the power to name anybody to make decisions. Okay. You could just get information. So is it legally binding? Yes, but is it what you need? I'm not sure. There's extreme flexibility, like I explained before. You can set this up however you would like. The cost is relatively minor compared to the cost of guardianship. You can kind of set up a succession plan for it. But it's again, it's very similar to that in a power of attorney. There's tons and tons of autonomy. I think this is the maximal amount of autonomy. There is recognition under the law, but again, not for decision making, and there is no court involvement necessary, which is great. No legal planning. You could see there's a lot of sad faces.
Yeah,
Uh,
not the most ideal solution.
no, not at all. The only benefit is actually, I should say, no planning does give the maximum amount of autonomy in theory. Um, and also, there's no court involvement until there needs to be an emergency guardianship, which is unbelievably expensive. And very few attorneys do it because it's just you have to drop everything and spend days upon days having evidentiary hearings. So you want to avoid that. So if you're going to plan, if any of these speak to you, go talk to an attorney and start having these discussions now before there is an emergency. All right. If you want an ebook on guardianship and guardianship alternatives, just shoot me an email. I'll just put it in the chat real quick. Also, if you just want to click on it, happy to send it over to you. I'm not going to spam you with anything. I'm just going to send you an ebook. And feel free to reach out to me and I'll send it to you within the next couple of days. It kind of goes what I went through, but also just provides a lot more information. And if that's helpful to you, great. And that's all I really have, Michelle. But I'm happy to answer any questions that people have.
Thank you so much, Randy. I have a couple more slides, but this is the perfect chance for anyone to put questions in the chat box. Randy, can you talk to us a little bit more about which tools that you've discussed can help protect your child against, fraud, someone coming up to them and trying to get them to sign a contract? I know
Oh,
that there are provisions in contract law where if you can prove that the person, talk to us a little bit about that.
yeah, that's a great point. I should have brought that up. Guardianship is really, in theory, the only tool that can prevent against fraud in the context of guardianship and guardianship alternatives. And I'll add something in a second because it removes an individual's legal right to be able to sign things. Practically, you just need to help your child not have access to their own money if they have their own money. Um, there's a lot of different directions I could take this answer, and I don't want to spend too much time, but if your child is not receiving means tested benefits and they have assets in their own name, there's a couple of things you can do to help them protect their assets. Number one is a different type of guardianship than I spoke about, which is called a voluntary guardianship. That's where your child can say, hey, I want mom to manage my money because I recognize I don't have the ability to do that. And they ask the court to put the guardianship in place. The other is potentially a special needs trust. It's a completely different topic, very long, but you can secure money, especially um, if an individual has money and they're getting means tested benefits, they um, they would need to put it into a special needs trust. But we often set them up for the parents who are leaving money to their children, God forbid, when they pass away, and that can be used to protect the your child.
That is fantastic. I do see another question, but I'm going to go through some of my slides, and then we'll get those questions. I think everybody's got your email in the chat box.
Perfect.
So these are some of the other things to keep on your radar in terms of planning for the future. And these are the things that we talk about at Consolidated Planning Group every single day with our clients. That future cost of care, the waiver programs. Every state has its own waiver program. SSI and SSDI, so those are federal benefits. They come with Medicaid or Medicare. And you definitely want to make sure you don't jeopardize those. So you can use an ABLE account to keep money for your loved one, or you can use a special needs trust. I did see a question that was delivered to us before this webinar about child support and how that affects things. It does not really affect guardianship very much, does it, Randy?
No, not at all.
No, but it does affect your special needs trust and the benefits for your child. Um, so you need to make sure that if there is child support in your life, if that's a thing for you, beyond age 18, it needs to get directed to a first party special needs trust.
Yes,
We talk,
absolutely.
yeah, yeah. We talk a lot about residential living communities and what's going to happen after you are not here or unable to take care of your loved one. The legal things and post high school educational opportunities. So if you have enjoyed, hearing from us today, you might want to check out some of the other webinars that we produce. Our upcoming webinars are all available through this link. It will be clickable when you get these slides later on today. So you can just click this link and register ahead of time for upcoming webinars. This is the entire team at Consolidated Planning Group. Again, we are located just outside of Houston, Texas, but we serve families all across the United States. We are members of the Academy of Special Needs Planners, members of the National Social Security Advisor Council, and we are special needs, chartered special needs consultants. So we really take this very seriously. We offer a completely free Zoom consultation. It would either be with myself or one of the other financial advisors on our team. And we will be reaching out to you to see if you're interested in scheduling this, because this is your opportunity to ask an expert any questions that you have left about, the special needs planning that we do and how things work and what you need to do for your loved ones. We'll answer your questions, learn a little bit about your family and your situation, give you some advice about what next steps you should take, and then talk to you a little bit about what we do and how we could help. You can use the QR code to schedule. You could call or email the office, or you can reach out to me directly. My information is in the chat box, and I'll put it in there again. And I would be happy to schedule that for you. And then this page also has our YouTube link, our Instagram, the podcast that we run, and our Facebook page. So please follow us on social media to get more out of your experience with Consolidated Planning Group. All right, so a couple of questions that have popped up for you, Randy. How long does the court process take, and when can we get started with that?
The court process for guardianship and guardian advocacy is about 30 to 60 days. It's supposed to be done within 30 days, but practically it's 30 to 60 days. And you should really speak with an attorney about 6 months before your child is turning 18.
Mhm.
Before that, there's not really too much you can do. And I, there hasn't been many changes in guardianship law over my career, but speaking with an attorney about this when your child is 14 or 16 or 15, whatever it isn't so helpful because there's not really any action that can be taken. So that's when you would start.
And that can't kind of answers Francesca's question as well, as when is it too soon? So instead of asking you that, what I want to ask is something that I get asked all the time. How much does this all cost? I mean, you mentioned the cost of different things, and how much does guardianship cost?
Yeah, so guardianship is in the ballpark of around $5,000 to open it up, doing all the initial reporting with the court, and then somewhere around 750 to $1,500 a year to do that guardianship reporting. Guardian advocacy is a little bit less than that. Um, and I mean, our firm, we could work with payment plans and we work across the state, but if you have your own attorney, phenomenal. Um, and yeah, that's the approximate cost.
About 5,000. Okay, great, great. Well, I don't see any other questions in the chat box. So, Randy, I just want to say thank you so much for being here with us today and presenting us with this information. It has been great to hear from you. And thank you to the participants for giving up 47-ish minutes of your time and being here with us today. I hope you've learned something that you can take away. I hope that you've set up your free consultation with Consolidated Planning Group and that you will receive these slides. So you're going to have all of our contact information. If you have further questions, please reach out to one of us. We do these because we are here to help you. Not, I mean, yes, it helps us stir up business, but we want to help. That's why we do what we do. So reach out to us and we will get back to you as soon as we possibly can. I hope you all have enjoyed. I hope you have a beautiful day and a wonderful week. Thank you so much for being here. Bye bye.
Bye bye, everyone.